I don't like this case one bit. Daniel Penny, 24-year-old ex-Marine, is sitting on a subway train. In comes a 30-year-old, Jordan Neely. By all accounts, he's raving, he's screaming. Someone is going to die on this train. Penny gets up, puts Neely into a neck hold, or very possibly a choke hold. When Neely gets to the hospital sometime later, he's pronounced dead. Penny's charged with 2 counts of homicide. Later in the trial, prosecution, questioning one of the witnesses, starts referring to Penny as the white man. Race should be completely unimportant to the law in a case like this. Manhattan District Attorney Alvin Bragg commits abuses of his authority as a prosecutor and does not deserve to be in office. How many men are left that are going to stand up, take a risk to their own personal safety to do what Penny did? Hello everyone, and welcome back to Straight Down the Middle. I'm Jed Rubenfeld, and I'm recording tonight from New York City, and you may hear a siren or two in the background during this episode, and that's normal. This is New York, and in a way it's kind of appropriate because today I'm going to be covering the trial of Daniel Penny. Penny stands accused of homicide, as many of you probably know, in the death of Jordan Neely on a subway train in Manhattan in May of 2023. Now, you know that on this show, I always present both sides of the argument. I'll do that tonight. But I also call them the way I see them. So I got to tell you, the way I see this one is, I don't like it. I don't like this case one bit. Honestly, I think it's a travesty. I think it should never have been brought. I think it's more evidence that Manhattan District Attorney Alvin Bragg commits abuses of his authority as a prosecutor and does not deserve to be in office. I know that's a harsh judgment. I've been waiting, have not been eager to do a show on this trial, been waiting for the government to have a chance to present its evidence. But that's happened now as I record this episode. All the evidence is in, the defense is rested, the jury will be charged probably in a couple of days. There will be closing arguments and we'll probably have a verdict not too long from now. But this case doesn't look good to me, and I'm going to explain to you exactly why. Okay, let's get started. So first, what are the facts and what is Penny charged with and what's the law? And then I'll explain to you what I find so troubling about this case. Criminal cases are all about the facts, and it's so hard to know what the real facts are, and that's why you got to wait for the trial and see what the evidence is, and even then, you can't be 100% sure what the facts are. And let me emphasize, I don't have any role in this case. I don't know the lawyers. I haven't obviously talked to any witnesses. I haven't read any transcripts. So the facts, as I recount them to you, are taken from newspaper reports. That's all I know, what I read in the newspapers about this case, and newspapers can get it wrong. But I believe that the facts as I recount them to you will be the ones that are widely accepted as the facts of this case, so let's get started. It's May 1st of 2023. Daniel Penny, 24-year-old ex-Marine, is sitting on a subway train in Manhattan. In comes a 30-year-old, Jordan Neely. Now, Neely has an arrest record, a criminal record extremely long. Over 40 arrests, some for charges that aren't that serious, turnstile jumping, others for theft, others for assault, including 3 unprovoked assaults on women in the New York City subway. Apparently, he's also suffering from serious psychiatric disorders. He comes on the train, and by all accounts, he's raving, he's screaming. He says, according to most accounts of people on that train, I don't care if I die today. I don't care if I go back to prison. I don't care if I go back to prison for life. Someone is going to die on this train. Other witnesses state that he said he was going to kill someone, but maybe what they're doing is interpreting the statement, someone is going to die on this train, which seems to be pretty well established. Neely starts lunging at people on the train, half lunging. He lunges at several different people. He makes his way down the train. There's a woman at the end of the car with a young child. She's hiding behind the stroller with her child. At that point, Penny gets up, puts Neely into a neck hold, or very possibly a choke hold, pulls him to the ground, puts his legs around him, restrains him, holds him for a period of time. When Penny releases him, there's no doubt that Neely is still alive. The cops come. Penny lets him go. The cops take over. He still has a pulse at that time, but when Neely gets to the hospital sometime later, he's pronounced dead. A coroner would later report that the cause of death was the chokehold that Penny put Neely in, although at trial, Penny's lawyers have disputed that and say, no, it wasn't the chokehold, it was the drugs in Neely's system. Now, what is Penny charged with? Penny's charged with 2 counts of homicide. Manslaughter in the 2nd degree and criminally negligent homicide. What's the difference? Manslaughter in the 2nd degree is committed in New York when a person acts recklessly. Criminally negligent homicide is committed in the state of New York when a person acts with a kind of gross negligence. What's the difference between these 2 charges? Well, recklessness and negligence share a common feature, which is that the defendant has to have, through his conduct, created a substantial and unjustifiable risk that the victim would die. Now, in reckless homicide, that's manslaughter, that's the higher charge, the defendant has to have known that he was putting the victim into a condition of substantial and unjustifiable risk, and he did it anyway. In other words, he had to know that there was a substantial risk that the person might die based on what he was doing and that there was no justifiable reason for doing so, and yet he went ahead and took the actions anyway. That's recklessness. That's manslaughter in the 2nd degree. Criminally negligent homicide, the difference is that the defendant didn't know that he was creating that risk of substantial, unjustifiable death to the victim. He didn't know that his conduct was creating a substantial risk, didn't know it was unjustified, but in the eyes of the law, he should have known. So if you're creating a substantial and unjustifiable risk of death, you don't know, but you should have known, that's criminal negligence. That's negligent homicide in the state of New York. Okay. Now, first question is, was Penny justified in using deadly force at all? You put somebody into a chokehold, that can be lethal force. So the first legal question is there any justification in the initial actions he took? Answer to that is almost certainly yes. The witnesses, the other passengers on that train car, many of them have testified they felt they were at risk of death. One witness says she was sure she was going to die. Another witness says she was afraid of death and afraid of the death of her child. All the witnesses seem to agree that Neely was acting dangerously, threateningly, said words like someone's going to die. At that point, it is a virtual certainty that Penny was justified in using potentially lethal force to restrain and stop Neely from committing any acts that would create danger of injury or death to other passengers on that train. It's important to emphasize that in the state of New York, as in virtually every state in the country, a person can act in self-defense, not only simply in defense of themselves, but also in defense of others. So, the initial question, did Neely have a justification in applying some potentially lethal force to Neely in order to stop him from what he was doing? Answer is almost certainly yes. Well, okay, Professor, then how can there be a prosecution here at all? What's the issue? I mean, the prosecution is saying that Penny didn't have any justification for using lethal force, but they're almost certainly going to lose or should lose on that issue. But still, they have a case. Now, I told you that I would present to you both sides of the argument fairly, and here's the strongest element of the prosecution's case. Penny kept Neely in that chokehold for 5 to 6 minutes. And the main claim made by the prosecution in the case is that's too long. Even if Penny was justified in applying that chokehold at first, he was not justified in keeping Neely in that chokehold for 5 to 6 minutes. There is some evidence that Neely had already been incapacitated after 3 or 4 minutes, and yet Penny kept him in that chokehold for another 2 minutes. That's what the prosecutors say. And that was either criminally negligent, taking a risk that he should have known to exist, or maybe even reckless. He knew that there was a risk of death after all. He was a Marine, he had had some training. He must have known that there was some risk that Neely would die, and yet he took the action anyway. That's what the prosecution says. So Maybe he's guilty of reckless homicide, that's the manslaughter charge, or at a minimum, he's guilty of criminally negligent homicide for extending that chokehold too long after Neely was incapacitated. You've even got some evidence that somebody on the train said to him at a certain point during the altercation, hey, he could die. Ease up, man. Now, we don't know for sure if Neely heard that, but there's some evidence that that was said. Again, that's evidence on the prosecution's side that Neely might have known that he was taking a risk, or should have known that he was taking a risk that was, according to the prosecution, unjustified. Okay, that's the strongest side of the prosecution's case. Now, let me explain to you the problems I'm having with this case. And I'm going to explain to you 3 problems that I think are quite serious, and some of which you probably have not read about in the newspapers, some of which other lawyers might not even have noticed yet in this case. Problem number 1, day 1 of the trial, opening arguments. The prosecution says to the jury, the standard for applying lethal force in New York is absolutely necessary. You cannot use lethal force in this state unless it was absolutely necessary to do so, and Penny cannot have applied that chokehold any longer than was absolutely necessary. That's a problem. Let me tell you exactly why. Because that's not the standard. The standard is whether a person in Penny's shoes could reasonably have believed that it was necessary to use that force. In other words, what the prosecutor left out there was that the test is whether a reasonable person in that subway car could have believed that it was necessary to use lethal force to restrain Penny. Not, was it absolutely necessary? That puts in the jury's mind that the question is like purely one of whether after 3 or 4 minutes was Neely incapacitated. That's not the question. The question is whether a reasonable person in Penny's shoes could have believed that Neely still posed a threat. The question is, could he have believed that? And guess who has the burden of proof on that? Not Penny, the prosecution. In other words, the prosecution has to prove beyond a reasonable doubt that no reasonable person could have thought that Neely still posed a threat to the people on that train car. So when you tell the jury he could not have held Neely in that chokehold for any longer than was absolutely necessary, he's committing 2 mistakes. The prosecutor is committing mistake number 1. He's leaving out the fact that the question is whether a reasonable person could have thought that Neely still posed a threat, and he's leaving out the fact that the prosecution's got to prove that no reasonable person could have thought that beyond a reasonable doubt. That's a serious error. Courts have been holding that that's an error for over 100 years in this country. There are cases going back over 100 years that say that prosecutors and judges cannot tell a jury that the test is whether it's absolutely necessary that lethal force was used. No, they have to be very clear. The test is whether a reasonable person might have thought that the lethal force was still necessary, and that the burden of proof is on the prosecution to show that no reasonable person could have thought that, and that it is error to tell a jury what the prosecution told the jury on day 1 of this case. Now, I'm confident that the judge will correct that error when the judge gives the charging instructions to the jury. I strongly am confident that the judge will get it right. But the jury's minds might still have been tainted by that deeply erroneous statement on day 1. I don't like that at all. Now, the errors that I'm talking about are going to increase in importance. That's the first one, and maybe that's the least important of the 3 errors that I'm going to be telling you about. Later in the trial, the prosecution, questioning one of the witnesses, starts referring to Penny as the white man. It was the witness who first used the description. The witness on the stand referred to Penny as the white guy. But the prosecution took that up, and on at least a half a dozen occasions referred to Penny as the white man. Now, why is that a problem? I mean, Penny is white, so why is that a problem? Well, it's a problem because we all know that although race should be completely unimportant to the law in a case like this, it is important in American society, and it can have an effect. That's right, Penny is white, Neely is black. Penny was initially let go by the police who were investigating and who questioned him. But after a couple of days, there was a eulogy given for Neely by Reverend Al Sharpton, who was a participant in the Tawana Brawley hoax over 30 years ago. If you don't know what I'm talking about, look it up. And then after that, there were protests and serious protests in the city of New York saying that the prosecution has to go after Penny because he's white and Neely's black, and it'll be a racial double standard if the city of New York doesn't go after Penny. So did race play a role in this prosecution? You know, I sure hope not. But on the stand, a witness is asked by the prosecutor 6 times about the white man, not referring to him as Mr. Penny or the defendant. Is that a problem? Well, just think if in a sexual assault prosecution some years ago in the South, or maybe today in any place in the United States where racial discrimination is still a problem, imagine the prosecutor referring to the defendant as the black man in such a case, and referring to him over and over as the black man. Did the black man do this? Did the black man do that? I think we would all see a big problem in that kind of reference, and I would hope that no judge would permit it. So I think we should see a problem when the prosecution makes those references, and maybe the judge should have stopped it, but the judge didn't. So that's a real problem, because one of the issues in this case is, does the fact that Penny is white, did that fact play any role in the prosecution's decision to go after this guy? I sure hope that's not true. But when the prosecution starts calling him the white man in open court, before a witness, in front of the jury, I don't like that one bit. Okay, finally, third problem. Third problem, I'm going to tell you about a case that was decided over 100 years ago in the Supreme Court of the United States, decided by none other than Justice Oliver Wendell Holmes, one of the greatest justices ever to have lived. The case is called Brown versus United States. It's interesting, the parallels between that case and this one. They're not exactly the same, but there are parallels. Let me tell you what they are. Brown was convicted of manslaughter. He's convicted of homicide. And there was little doubt that in the case, the shots that were fired by Brown, he had shot the victim dead, were fired after the victim had threatened Brown. The victim had apparently said things like, "Next time I see you, one of us is going to leave in a coffin." And he had approached the defendant, Brown, at his place of work with a knife. The defendant, Brown, shot the victim and killed him. And there was some evidence that the 4th shot was fired by the defendant after the victim was on the ground. And some evidence that that 4th shot fired after the victim was already on the ground, shot 3 times, might have been the one that killed him. And the defendant, Brown, was convicted of homicide. The case went all the way up to the Supreme Court of the United States, and Justice Holmes, on behalf of the full court, reversed that conviction. Said, nope, he's not guilty. Now, that case is known for the Supreme Court's lending its voice to the stand your ground rule. That is the rule which is followed in most states in the United States, that somebody threatened with lethal force does not have to retreat, but can stand his ground and defend himself. But there's something else that Justice Holmes said in that case that's very important to the Penny case. It has to do with that 4th shot. And Holmes said, even if it's true that the defendant fired that 4th shot intentionally, there was some dispute about that, it wasn't an accident, that he fired that 4th shot intentionally and the victim was already on the ground at that point, even then, the defendant doesn't lose his immunity, his right to act in self-defense. That's what Justice Holmes said. Because if the heat of battle was still on, the defendant cannot be expected or cannot be judged in the light of cool reflection after the fact. Even though it may seem not to have been necessary in cold blood for the defendant to have fired that shot, that's not the standard by which to judge somebody who fires that 4th shot if the heat of conflict is still on, and in that heat of conflict, the defendant still believed that he was fighting for his life. I'm quoting from the Supreme Court there. Detached reflection, said Justice Holmes, cannot be demanded in the presence of an uplifted knife. So you see, Brown versus United States was also a case about excessive lethal force being used by somebody who had a right to use lethal force at first. In that sense, it's a lot like the Penny case, because that's the prosecution's claim. Even if Penny had a right to use lethal force at first, he went on too long, excessive. But Justice Holmes said, if in the heat of conflict, the defendant still thought he was fighting for his life, you cannot judge him after the fact, in hindsight, by the calm reflection and the view that might be taken after the fact of what seemed necessary or unnecessary. That's the wrong standard, said Justice Holmes. Now, Holmes's opinion in Brown versus United States is not binding. In this case, it was not a constitutional decision. It was an interpretation of federal homicide law. New York courts are not bound to follow it. But New York courts have quoted that very famous opinion and that sentence that I just quoted to you from Mr. Justice Holmes in that case. The highest court of the state of New York has quoted it, cited that case approvingly, and you might think it strongly applies here. What the prosecution is doing is it's trying to judge Penny in the light of hindsight and saying that if somebody after the fact, coolly, calmly looking, might have thought that after 3 minutes it was time to let go. But in the heat of conflict, said Justice Holmes, that's not the right standard. Okay, those are three big legal problems I have with this case. But you know what? The real problem I'm having may not even be technically a legal one. Let me explain to you what that real problem is. I'm going to be honest about it. I'm going to tell you exactly what I think. New Yorkers know that when you get on the subway, folks can come in who are acting crazy, who can be a threat, and you are trapped there. You're a prisoner on that train. There are very few people left in this country. How many men are left that are going to stand up and take a risk to their own personal safety to do what Penny did? To take a risk of their own personal safety and try to subdue somebody who might be a threat, who might be a little crazy, who might respond to them with lethal force. Daniel Penny was one of the few who was willing to do that. And guess what, after this case? There are going to be even fewer still. Because now, somebody sitting on that train, they're going to be thinking, even if they had the courage to stand up and defend others, who's going to do that now? Who's going to stand up, take that risk, knowing that if they do that, they could end up on the stand themselves, not given a medal, but rewarded with a prosecution for homicide? I think this prosecution is putting people in danger. I think that they should have found something very different to do with Mr. Penny and very different to do with this case. He should be commended for what he did on that train, not prosecuted like a murderer. That's my honest opinion about it. And I got to tell you, there's somebody who may be also responsible for the death of Jordan Neely on that train, whose negligent actions resulted in the death of Jordan Neely on that train. And I got to tell you exactly whom I'm talking about, and that's District Attorney Alvin Bragg himself. What do I mean by that? District Attorney Alvin Bragg announced on his first day of office that he was going to stop prosecuting a bunch of crimes, including turnstile jumping. That is, no police were ever going to arrest anybody for getting on the subway again without paying. And we know that Bragg has been letting people off, letting people out of prison, not prosecuting a host of other crimes. Well, there was just somebody, just a couple of weeks ago, another crazy guy, been in and out of prison, arrested, let go, arrested, let go, arrested, let go, and then just recently went on a killing spree and killed 3 defenseless people in New York City all in one night because he'd been let out after being arrested. Yeah, I'm going to say that District Attorney Alvin Bragg's policies may have led to that or to other offenses and crimes and killings committed in this city. And that's a terrible shame. And what I'm saying is that his policies may have negligently or even recklessly led to these deaths. Mr. Bragg, wouldn't it be better to put the bad guys away before you prosecute good guys who tried to save innocent people on a train from getting killed by somebody who was conceitedly suffering from psychiatric disorders and conceitedly was threatening people on that train? Mr. Bragg, wouldn't it be better to get people off the streets of New York, dangerous people who've committed crimes and been arrested, rather than letting them go so that they end up going on killing sprees and killing 3 innocent people? Couldn't we do a little of that before we prosecute for homicide? Somebody who tries to the best of his ability to save other people from being hurt on a train in your city. I've been harsh in these statements, but I'm calling it how I see it. And that's all I got for you for tonight. Stay tuned for more episodes of Straight Down the Middle.